Anishinaabe, hello friends. It's a pleasure to have this time with you today. As you may know, today is an Indigenous Peoples Day celebration. So if you celebrate, I hope you are enjoying the day. And regardless, I hope you're enjoying the day. Really glad that you could be here with us today. And I'm excited to share with you some work that I'm currently working on for research and what I think is probably going to be a multi-year project, both in kind of updating you on some research that's happening here at the U and also welcoming you for any thoughts that you might want to share as we look to into this topic. I do want to start off, as I like to do anytime that we are gathering here in the Salt Lake Valley, which is where I'm currently located today. I do want to acknowledge that this land, which I'm on, is named for the Ute tribe and is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples in their traditional homeland. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native Nation and urban Indian communities through research, education, and community outreach activities. And this CLE series that we run here at the S.J. Quinney College of Law is certainly part of those community outreach activities. And again, very excited to be talking to you about Indian law on Indigenous Peoples Day. I do want to share a little bit before I get into the presentation of kind of the origin for this work. So this kind of thought process or experiment of thinking about how a theory of originalism interacts with Indian law came about over a year ago now when I was invited to speak at the 10th Circuit Bench and Bar Conference in Colorado. And we were speaking about kind of the downstream impacts of a relatively recent U.S. Supreme Court case, McGirt and Castro Huerta, on Indian law. And when we opened it up to questions and answer time period, somebody asked the question of whether originalism could kind of get to the quote unquote correct results in Indian law. And I thought it was a really interesting question. And at the time on the panel, I said, yes, I thought that it could. And as I've thought more deeply about it and done research into the topic, I've even come to more of a conclusion that originalism could really help us in terms of understanding the correct interpretation of Indian law. And so I'm going to share with you today what I anticipate is going to be the first article in a series of articles on the intersection of originalism and a federal Indian law. And before we get into today's presentation, I do want to acknowledge one of our current students here at the S.J. Quinney College of Law, Isaac Santos, who has helped so much with this project. And in fact, I incorporated some of his research into today's presentation. And he'll be co-authoring the first of these articles with me. And so I'm incredibly thankful to Isaac and all he has done and all he's going to do on this presentation. So first, let's go ahead and kind of look at an overview of what we're going to cover in the presentation. So first, a very brief introduction to originalism and certainly how I'm using that phrase in talking about the theory and the construct. Then we're going to dive into kind of what was the original understanding. So we're going to look at the U.S. Constitution and its mention and interaction with tribes and tribal governments. We're going to look at then tribal sovereignty as it existed both at the founding and today. We're going to look into the three different methods that currently exist for abrogating tribal sovereignty. And then we're going to focus our time on, again, what's going to be kind of the first article in this series of articles that I'm hoping to write, which is how specifically implicit divestiture, which allows for the abrogation of tribal sovereignty through implicit divestiture, how that would interact with an originalism framework. And just to give a little preview, I think ultimately that originalism would tell us that implicit divestiture, there is not justification for it based on kind of the understanding of tribes, tribal governments, the Constitution, and certainly both the founders' understanding, and then also kind of the society's understanding at the time that the United States was founded. So excited to get into that with you. First, so what am I talking about when I mention originalism? And really what I'm getting into here is that the Constitution should be interpreted according to its original meaning at the time it was ratified. But again, kind of the core principle of originalism, as I'm talking about it today, is this idea that the Constitution should be interpreted according to its original meaning at the time it was ratified. The idea of originalism here that I'm using today is that the constitutional meaning was really fixed at the time of its adoption. And that this original meaning should govern our interpretation today, especially something as core as the relationship with tribes and tribal governments, which certainly existed at the time of the founding of the United States. So this isn't a topic that we're talking about today that's kind of thinking about how originalism or the Constitution would answer kind of a quote unquote modern challenge. These are tribal governments have pre-existed the United States. And so the relationship between the federal government and tribes remains in place today. I would contrast this view of originalism with kind of the idea of living constitutionalism, which would say that the meaning of the Constitution could evolve over time. So that's how I'm contrasting that, excuse me. And then there's really kind of two variants of originalism. Originally, the focus as this theory was developed in the legal scholarship really focused on the intentions of the framers who drafted the Constitution. So really driving into what the founding fathers thought different provisions of the Constitution meant. And this was, as I mentioned, kind of the earliest form of the theory of originalism as a method of legal interpretation. Today, that's evolved over time into more of an original public meaning, meaning that we focus, certainly the founding fathers can be indicative of how things were interpreted, but we can also expand that to how a reasonable person at the time of ratification of the Constitution would have understood the constitutional text. This is why oftentimes you see originalist discussions looking at dictionary definition terms or how terms were understood at the time of ratification, because this is consistent with how a reasonable person would have understood it. And this is currently the dominant form of originalist thought, but certainly the original intent theory is still there as well. And we'll talk about both of these today as we kind of go on our journey looking into Indian law and how it intersects with originalism. So there are many justifications for an originalist perspective on judicial decision making. The first is kind of democratic legitimacy, that the Constitution derives its authority from the ratification of we the people. And so interpreters should be bound by what was actually ratified at the time. So again, that goes back to the idea that we should look at what a reasonable person thought at the time of the adoption of the Constitution in understanding what the provisions of the Constitution were meant to mean. Also, and this is another thought that we're going to come back to quite a bit today, the idea of the rule of law is that fixed meanings provide a constraint on judicial discretion and predictability. Originalism really pushes back on the idea that judges should be making law. And by saying that we should interpret the Constitution as it was understood at the time of the founding, or as we're looking at amendments later on at the time that the amendments were adopted, it's really kind of putting, if you will, guardrails on judicial decision making and saying that this is the realm within which judges can make a decision. Also, there's separation of powers justification, very similar to the rule of law. The idea is that the judges should apply law rather than making it, and that updating the Constitution, and so in other words, that idea of a living Constitution that evolves over time, is really playing the role of what was the amendment process. So the founding fathers certainly created a process through which the Constitution could be amended, but that was the amendment process, and we shouldn't allow for judges to have an evolving interpretation of the meaning of the Constitution outside of that prescribed amendment process. If we look at this book, and I encourage you, if you're interested in kind of modern originalism, to read this book written by Justice Scalia, A Matter of Interpretation, Federal Courts and the Law. In the preface to the book, it's pointed out that kind of the core principle here is that, quote, laws mean what they actually say, not what legislators intended them to say, but did not write into the law's text for anyone to read. And this is, again, an idea that we're going to come back to when we take a deeper dive into implicit divestiture and really start to question what it was that the framers were intending through the Constitution, and also certainly what the reasonable person and the founding fathers would have believed vis-a-vis tribes and tribal sovereignty at the time of the founding of the United States. Now, just it's worth noting that originalism does, as with most legal theories, have its critics. One criticism is that it can be very difficult to determine any sort of historical meaning with certainty. There's also concerns that there could be unjust outcomes applying 18th or 19th century understandings to modern problems. And then there's also questions about whose understanding counts. So again, we kind of talked about the two different variants of originalism, looking at the framers and the founding fathers versus kind of the general public and a reasonable person, or the ratifiers. But I think in this context that we're talking about today, a lot of these criticisms are really addressed. So first, as I mentioned before, we do have quite a bit that's been said about what was the understanding of the relationship between the federal government and tribes at the time that the United States was formed. Additionally, this is not a quote unquote modern problem. Tribal sovereignty existed, and the scope of tribal sovereignty is something that has been known about and has been discussed, has been the subject of Supreme Court decisions since 1823. So this is not something where we're applying quote unquote outdated norms and understandings to really modern problems. So certainly there are criticisms of originalism, but I think it's actually an interesting tool in theory to look at Indian law from. So let's take a deep dive into what the U.S. Constitution actually says vis-a-vis tribal sovereignty and tribal governments. And we're going to focus on tribal sovereignty because when we get to implicit divestiture, it's a doctrine that says that elements of tribal sovereignty have been divested through historical developments. And so I think it's really helpful to understand what was the understanding of tribal sovereignty at the time that the U.S. was founded, as articulated in the Constitution. Then also we'll take a look at some of what the founding fathers and certainly a reasonable person might have thought back in the 18th century. So first, the U.S. Constitution. So Article 1, Section 2, Clause 3 is the apportionment clause, and it specifically mentions that in terms of apportionment, that Indians who were not taxed were to be excluded in terms of representation and taxation. This is important, right, because it presumes that Indians generally do not fall under the authority of the federal government, both because it acknowledges that Indians could not be taxed at that particular time. Now, certainly there were folks who were Indian who would have been part of the general population and paying taxes, but in general, it was the idea that Indians were not taxed. And that remains true today. Tribal governments are generally not taxed unless they're engaged in activities that are not related to governmental functions. And then also it's relevant because it presumes that Indians and Indian tribes are not going to be represented in the newly formed government, which again suggests that tribes and individual Indians are somehow other or separate from the federal government and from the states. Now, if you're wondering why I use the term Indian, I sometimes get that question, just a quick little sidebar. I personally use the term Indian for two reasons. First, when we're talking about law, it is the legal term used to refer to indigenous peoples from the United States of America, and that's codified in the Indian section of the U.S. Code. Also, for me personally, I'm a citizen of the Sault Ste. Marie Tribe of Chippewa Indians. So my tribe specifically uses the term Indian. So I'm very comfortable with that term as a result. You're certainly not required. If you, for whatever reason, are not comfortable with the term, that's fine as well. You can always refer to somebody by their tribal affiliation, or if you prefer, you can always use Native American or American Indian. So just a little sidebar on why you'll hear me using the term Indian today. And then we have Article 1, Section 8, Clause 3, and this is probably the most commonly cited to clause when we talk about federal Indian law because it's the Commerce Clause, of course, and it grants Congress, not the states, the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So many things are very important about that clause. First, notably that Indian tribes are singled out as something separate. And we know from subsequent decisions from the U.S. Supreme Court in Cherokee Nation versus Georgia, where the court defined Indians as domestic dependent nations. So tribes are indeed something else. And then also specifically references them as an other, and it suggests that the federal government doesn't seek to apply the Constitution to tribes, as tribes are in the same kind of sentence along with foreign nations. So it's really important for our purposes of kind of understanding what was the status of tribes and tribal governments at the founding of the United States by looking at that Commerce Clause and specifically to see that Indian tribes are mentioned as an exception. Interesting side note here. It is resoundingly believed, and I don't believe even a topic of conversation, that the U.S. Constitution and the amendments do not apply to Indian country. And that's because tribes at the time of the founding were outside of the federal government. And so it wasn't until 1968 and the passage of the Indian Civil Rights Act where many of the protection of the Bill of Rights were applied to Indian tribes through federal statute. Interestingly, there are still several exceptions. So, for example, the Indian Civil Rights Act does not have a separation of church and state clause. And so, as a result, we have tribes that are religiously governed or theocracies. And so there is that intertangling. So there are a couple of exceptions, but in general, the Bill of Rights today has been applied to tribes through the Indian Civil Rights Act adopted in 1968. We can also look to the treaty making authority, Article 2, Section 2, Clause 2, which is the treaty clause, and it gives the president the power to make treaties with the advice and consent of 2/3 of the Senate. Now, notably, tribes are not specifically referenced in the treaty clause, unlike the Commerce Clause. However, despite the lack of this language, the federal government treated Indian tribes as sovereign nations and entered into treaties very much the same way it would enter into treaties with foreign nations of the time, from 1778 to 1871. In 1871, Congress passed legislation that ended the practice of treaty making with Indian tribes at that particular time. But we can see that Congress did end that practice in 1871. So certainly from 1778 to 1871, we can see that the United States treated tribes as separate sovereigns, as evidenced by the extension of treaty-making authority for the president to tribal governments. Interestingly, prior to 1778, many of the treaties were the British government treated tribes the same way. So there were treaties that pre-exist 1778 between the British government, and tribes. So the federal government just really extended what had been the British policy. Now that we've kind of looked at the Constitution and what the Constitution says about the tribes, which admittedly is not much, because again, the founding fathers certainly didn't believe that the U.S. Constitution applied to tribes. we can now look at kind of what was the broader understanding of tribal sovereignty at the time of the founding of the United States. So again, the Commerce Clause certainly distinguishes Indian tribes from both foreign nations and the states, suggesting that they were a separate and distinct sovereign entity. It also is consistent with the Indians not taxed language, which suggests that tribes were outside the direct governance structure of the United States. This is also consistent with the treaty-making process that we talked about in terms of the Continental Congress and the early United States negotiating formal treaties with the tribes, and the United States starting that practice in 1778. But really, again, this is an extension of a process that had been used prior to 1778. And this really recognized tribes as sovereigns capable of entering into binding agreements. We can also look to the Northwest Ordinance, which was adopted in 1787, which declared that, quote, "the utmost good faith shall always be observed towards the Indians. Their lands and property shall never be taken from them without their consent." So all of this suggests, and again, kind of going to that reasonable person understanding of what would have been true, that in fact, that tribes were separate governments with sovereignty at the time of the founding. Next slide, please. So let's look a little bit deeper into how the court has articulated tribal sovereignty. And here we can kind of look at both the origins of tribal sovereignty and then also the extent of tribal sovereignty after the founding. So we can look to several court decisions. Interestingly, the Supreme Court has affirmed tribal sovereignty even to modern times. Recent decisions such as Brackeen all affirmed tribal sovereignty. In McClanahan versus State Tax Commission, the U.S. Supreme Court said, quote, "It must always be remembered that the various Indian tribes were once independent and sovereign nations, and that their claim to sovereignty long predates that of our own government." So just affirming that tribal governments pre-existed the formation of the United States and were here before the current United States was in existence. Also, we can see that Congress has in certain ways regulated the manner and extent of tribal power and self-government, but Congress has not created that power. So that's important because it's a recognition that tribal sovereignty is not a delegation from the federal government, but is rather implicit and inherent within tribal nations. Notably, in Worcester versus Georgia from 1832, the U.S. Supreme Court mentioned that both the colonization and the later founding of the United States did not extinguish tribal sovereignty, so tribal sovereignty persists. Again, the U.S. Supreme Court has upheld that numerous times over the centuries. And then here we can see that the U.S. Supreme Court has recognized that tribes are distinct, independent political communities that possess and exercise sovereign authority, starting in 1832 with the Worcester versus Georgia decision, all the way up to quoted language in the United States versus Cooley decision from 2021. And there's also even more recent decisions where, as part of the decision making of the U.S. Supreme Court, it recognizes that tribal sovereignty exists. So certainly at the time of the founding, there's evidence both in the Constitution and from what the founding fathers said that there was tribal sovereignty that existed. Tribes had the ability to govern and regulate themselves. And we can see that the U.S. Supreme Court has upheld that throughout the centuries, even up to modern times. And interestingly, every president has, since Richard Nixon in the quote-unquote modern era, has recognized the sovereignty of tribes and the self-determination authority of tribes. So it's not only the judicial branch, it's also the executive branch, and certainly there are numerous statements from the legislative branch as well supporting an articulation of tribal sovereignty. So I think it's pretty well agreed that tribal sovereignty certainly existed at the time of the founding of the United States and continues to persist today. But that brings us to this question that I'm kind of interested in digging into, which is whether or not tribal sovereignty can be abrogated, and if it can be abrogated, how it can be abrogated. So that leads us to our next slide, Spencer. So there are three mechanisms under the law today through which tribal sovereignty can be abrogated. So first, we'll take a look at how tribal sovereignty was abrogated kind of at the founding by virtue of tribes' position vis-a-vis the federal government and recognition that tribes have a domestic dependent status. The courts have consistently held that tribal sovereignty was abrogated through the founding and that status that exists. Further, courts have recognized that tribal sovereignty can be abrogated through an express or clear statement from the political government, specifically Congress. And that through congressional acts and treaties. So, of course, tribes can agree to abrogation of sovereign authority. And then also, starting in the late 19th century, we had a recognition that Congress has plenary authority over tribes by virtue of the dependent status that tribes have to the federal government. And so, therefore, it was Congress that was determined in United States versus Kagama to have plenary authority over tribes. And so, therefore, moving forward, if Congress explicitly expresses its intent to abrogate the authority of tribes, then it's been upheld that Congress has that authority by virtue of the plenary authority. And then there's this third way, which I'm really kind of interested in digging into and seeing if it truly can be justified, especially from an originalist lens, of implicit divestiture. And so we'll spend time talking about that. But first, the domestic dependent status. So as mentioned earlier, there were several early U.S. Supreme Court cases that articulated that the process of colonization necessarily limited the nature of tribal sovereignty, and that because of the relationship between tribes and the federal government, that some vestiges of sovereignty had been diminished. And the two kind of examples from the quote-unquote Marshall trilogy of cases, named such because we had Chief Justice Marshall in charge at that time, and also his opinions in these cases kind of won the day historically, if you will. But in Johnson v. McIntosh, the Supreme Court and Chief Justice Marshall, in his opinion, explained that because of the dependency and the relationship between the federal government and tribes, that tribes had lost their ability to freely alienate their land. So, in other words, the federal government, i.e., Congress, has the authority to alienate federal land, not the states. So interestingly, that's going to come up kind of in modern U.S. Supreme Court cases where the states had attempted to buy tribal land back at the time of the early founding of the United States in the 18th and very early 19th century. And the U.S. Supreme Court has said that states couldn't do that because it was only Congress who had that authority. Yes. And then also the tribes, through their relationship with the federal government, lost the exercise of certain quote unquote external powers, such as entering into treaties with foreign nations, kind of national protection rights, the ability to form militias, etc. Those are all external powers that tribes were seen to have lost by virtue of their dependency upon the federal government. Spencer, next slide, please. And then we, of course, have an explicit statement can be made by Congress saying that certain aspects of tribal sovereignty have been divested. And this is linked to that recognition that it's Congress that has plenary power. So Congress does possess significant authority, although not absolute authority. So Congress is, of course, constrained by the U.S. Constitution, Bill of Rights, for example. But Congress does have the authority over tribes, and that was probably most recently recognized explicitly in Holland versus Brackeen in 2023, where the quote says, quote, the court says, quote, "We have never wavered in our insistence that Congress's Indian affairs powers is not absolute, but is significant." And then we see several places where this U.S. Supreme Court has affirmed that over the years. So plenary power is subject to limitations such as guardianship and constitutional restrictions, but is rather significant. And then from this, the Supreme Court has recognized that tribal sovereignty can be abrogated through some sort of express or clear statement from Congress or through treaty. Again, tribes had the ability to abrogate their tribal sovereignty through treaty up until the end of treaty making in 1871. So, for example, in Montana versus Blackfeet Indian tribe, the U.S. Supreme Court held that, quote, the court consistently has held that it will find Indians exemption from state taxes only when Congress has made its intention to do so unmistakably clear. So, in other words, absent a congressional statement, state taxes don't apply. In Bryan versus Itasca County, similarly in 1976, the court held that Public Law 280 jurisdiction does not extend to state regulatory law because Congress didn't explicitly say so. Similarly, in 1978, in Santa Clara Pueblo versus Martinez, the U.S. Supreme Court held that there was no judicial review for the Indian Civil Rights Act. You remember that that's the act that applies the protection of the Bill of Rights to, or many of the protections of the Bill of Rights to Indian country, and limited, however, federal court review of the ability to bring claims under the Indian civil rights to the federal courts to habeas corpus, because it was only habeas corpus protections which were explicitly mentioned. In other words, it could not be extended to the federal courts where Congress did not specifically give the federal courts that authority. Spencer, next slide, please. But what about implicit divestiture? So we said that kind of the third category for abrogating tribal sovereignty is this idea of implicit divestiture. And so this doctrine really didn't emerge until 1978, which of course was over 200 years after the founding of the United States, in a decision called Oliphant versus Suquamish Indian Tribe. The U.S. Supreme Court articulated the idea of implicit divestiture. And what's going on in Oliphant is the Supreme Court is specifically looking at this question of whether whether tribal governments have jurisdiction over non-Indians who commit crimes within the reservation. So there wasn't a question as to whether or not tribes had jurisdiction over tribal citizens. They do. Later, the Supreme Court addressed the question of whether tribes had jurisdiction over non-member Indians, so Indians who committed crimes on another reservation. So, for example, myself being a member of the Sault Ste. Marie Tribe of Chippewa Indians, if I were to commit a crime on the Navajo reservation, would the Navajo Nation have jurisdiction over me? The answer to that was yes in United States versus Laura. But this specifically, Oliphant's dealing with the question of whether tribes could extend their jurisdiction to non-Indians. And this is where the court develops the idea that it's through implicit divestiture that tribes have been divested of that element of their sovereignty. So sovereignty would certainly hold that a sovereign would have jurisdiction over anybody who commits a crime within its territory. We see this both in terms of territorial criminal jurisdiction for the states, certainly for all those except for individuals with diplomatic status in foreign nations. So this is very much consistent with the idea of sovereignty. But interestingly, in 1978, the U.S. Supreme Court said that the tribes' retained powers are not such that they are limited only by specific restrictions in treaties or congressional enactments. So we're moving away from the requirement that there be an explicit congressional statement. As the Court of Appeals recognized, Indian tribes are prescribed from exercising both those powers of autonomous states that are expressly terminated by Congress and those powers, quote unquote, inconsistent with their status. So again, really big seismic shift in 1978, moving away from what had been the pattern of the U.S. Supreme Court prior to 1978 of looking for an explicit congressional statement towards saying that tribes no longer had those powers that were, quote unquote, inconsistent with their status. And the court goes on to explain that protection of territory within its external political boundaries is, of course, as central to the sovereign interests of the United States as it is to any other sovereign nation. But from the formation of the Union and the adoption of the Bill of Rights, the United States has manifested an equally great solicitude that its citizens be protected by the United States from unwarranted intrusions on their personal liberty. The power of the United States to try and criminally punish is an important manifestation of the power to restrict personal liberty. By submitting to the overwhelming sovereignty of the United States, Indian tribes therefore necessarily give up their power to try non-Indian citizens of the United States, except in a manner acceptable to Congress. So again, saying that through this relationship with the federal government, now all of a sudden that this extends to a finding that the federal or that tribes have no longer have the right to jurisdiction over non-Indians committing crimes within Indian territory. But again, that was not part of when we kind of look back at the history of the founding of the United States, certainly of the Constitution. We don't really see that there's evidence that that was the understanding either of the founding fathers or of individuals, like, kind of a reasonable person standard at that time. Spencer, can you give us the next slide? So we also saw implicit divestiture extended explicitly to the civil realm, and this happened in 1981 in a case Montana versus the United States, where the U.S. Supreme Court found that tribes had necessarily been implicitly divested over their ability to have authority over non-natives and non-Indian land within Indian country. This was a case where the Crow Nation was seeking to regulate non-Indians who had come on to the Crow Reservation to engage in fishing. As you may know, if you've seen a river run through it, there are amazing blue ribbon lakes and streams in Montana, and one of those is on the Crow Reservation. And so the Crow Reservation was seeking to legislate and to regulate the activities of non-natives. Now, for a wide variety of historical reasons, there are non-natives who own land within Indian country. So you can have land that is owned by non-natives within a tribe's exterior boundaries. And the court for the first time said in 1981 that in that circumstance, that the exercise of tribal power beyond what is necessary to protect tribal self-government or to control internal relations is inconsistent with the dependent status of the tribe. So really extending this idea of implicit divestiture in the civil realm as well. The court goes on to say, since regulation of hunting and fishing by non-members of a tribe on lands no longer owned by the tribe bears no clear relationship to tribal self-government or internal relations, the general principles of retained inherent sovereignty do not authorize the tribe to regulate it. So you see that implicit divestiture is now saying that sovereign powers only to the extent as they bear a relationship to tribal self-government or internal relations. And then the court concludes that though Oliphant only determined inherent tribal authority in criminal matters, the principles on which it relied support the general proposition that inherent sovereign powers of an Indian tribe do not extend to the activities of non-members of the tribe. So again, really what we've done with implicit divestiture is certainly moved away from an originalist understanding of Indian law, right? From an understanding of what was the scope of tribal sovereignty at the time that the United States was founded, either from the founding fathers' perspective or from a rational person's perspective, to say that this is somehow tribes have just been divested over time by virtue of their dependent status. So I would certainly make the argument that both implicit divestiture as articulated in the Oliphant decision in 1978 and then again in the Montana decision in 1981 would be inconsistent with an originalist understanding of Indian law. Spencer, can we switch to the next slide? So how does this come all together? And I would certainly argue that Justice Gorsuch has developed a path that brings us to a similar conclusion. And again, I encourage you to read Justice Scalia's book, A Matter of Interpretation, Federal Courts and the Law, because I think a lot of what he writes there can also be utilized to say that implicit divestiture is not consistent with an originalist understanding of Indian law. So Justice Gorsuch has really started to develop this idea of the intersection of originalism and Indian law. in his dissent in the case of Oklahoma versus Castro Huerta, which was a case looking at whether or not the state of Oklahoma still had criminal jurisdiction over non-natives following the court's determination in McGirt. In McGirt, the U.S. Supreme Court found that the Creek territory within Oklahoma had not been diminished because there was no explicit congressional statement saying that it had been diminished. In fact, you could make an argument that in McGirt, the majority opinion actually denies an extension of implicit divestiture because many of the arguments being made in the McGirt decision were that the Creek Nation had lost or its territory had been diminished because of kind of changed circumstances, the demographic makeup, and the fact that the state had been prosecuting crimes there. And the court rejects that in McGirt. So certainly saying that there was not implicit divestiture when it comes to the territory of the Creek Nation. So then Castro Huerta is the second of these cases and is really looking at whether or not the state can continue to prosecute non-Indians. So tribes can prosecute because tribal authority hasn't been diminished, but does that necessarily mean that the state has been excluded? And Justice Gorsuch would say that if we look back to the Worcester decision from 1832, we can see that Chief Justice Marshall refused to endorse Georgia's view there to assert its authority over tribal lands, establishing that, and this is Justice Gorsuch's language, that Native American tribes retain their sovereignty unless and until Congress ordains otherwise. He emphasized that, quote, where this court once stood firm, today it wilts. So saying that, we've moved away from these foundational principles of interpretation. And again, I think we can make the argument that we've moved away from an originalist understanding of Indian law. Similarly, in Justice Gorsuch-Brackeen concurrence, which grounded the Indian Child Welfare Act's constitutionality in an original constitutional design, Justice Gorsuch argued that the framers deliberately created an exclusive federal authority over Indian affairs to prevent the conflicts that had plagued the Articles of Confederation. And so therefore, the Indian Child Welfare Act, through which the federal government regulates the state process, or the state tells the state courts that they have to look at whether or not an Indian child is a citizen of a tribe or is eligible for membership. And if they are, then has to pursue certain avenues, that this was a proper exercise of the federal power vis-a-vis tribes. So again, kind of going back to that understanding, originalist understanding of what was the federal government's and specifically Congress's authority. I think also an argument could be made that this is consistent with Justice Scalia, as he argues in A Matter of Interpretation, Federal Courts and the Law. And he's really thinking through what is the role of the jurist, what is the role of the judge. And he has real concerns, as if you read the book, with this idea of the development of common law and its process, because the idea that you should kind of think to look at what the outcome should be, rather than really grounding it in an originalist interpretation, can not be appropriate, because then eventually you have individually what may seem like reasonable judges making decisions, but then move the common law in a direction that's not moored in an understanding of what the Constitution was originally supposed to be. And that goes back to when we were talking earlier in the presentation about the foundations and kind of the core principles of originalism. I think also powerful tools that could align with this decision as well would be Marbury versus Madison, of course, one of the quintessential early decisions of the federal government, stating, quote, it is emphatically the province and the duty of the judicial department to say what the law is. So in other words, in Marbury versus Madison, the U.S. Supreme Court said it is not the job of the courts to adopt what they think the political branches think or want them to do. And we see that in implicit divestiture. If we had time to go through the sources of law that the U.S. Supreme Court uses in that 1978 Oliphant decision, you'll see that it's all evidence that was not actually enacted. It's all things where Congress potentially thought about divesting tribes of their external sovereignty and jurisdiction over individual Indians, but never actually kind of pulled the trigger and passed the law saying that this had actually happened. So that would be inconsistent with Marbury versus Madison and this idea that the court is to say what the law actually is, not what it thinks the law is going to be, or what it thinks Congress might be thinking about the law. Also, we can look to the Indian canons of construction. So the Indian canons of construction are a specific method of both treaty interpretation, and later it was extended to statutes. And the Indian canons of construction say that really are complementary of originalism in this space, because they say that in sum, there are three elements of the Indian canons of construction, but that ambiguities are to be viewed in favor of tribes, but that more importantly for our purposes here are to be understood as tribes would have understood them at the time of enactment. So certainly if we go back and we look both from an originalist perspective at what is the scope of tribal sovereignty, and then also add in the Indian canons of construction, which say that we would look at what the tribes would have understood their conception of tribal sovereignty, I don't think either of those conceptions would have allowed room for implicit divestiture, right? This idea that somehow tribes could implicitly over time be divested of their authority. So I think regardless of whether you're kind of looking at from the federal perspective and the originalism perspective of what was the understanding at the time, or if you're looking through an Indian canons and construction and looking at what tribes would have understand, I think the result is ultimately pretty much the same, which is that there's not space in either view to recognize implicit divestiture. And so, Spencer, can you show us the next slide, please? So ultimately, the conclusions that I have on this question of implicit divestiture, and again, this is kind of the first piece in what I think is going to be multiple pieces of looking into common law as it's developed vis-a-vis tribes, is that originalism really calls into question implicit divestiture, right? Because when we look at the understanding of tribal sovereignty, either from a founding father's perspective or a reasonable person's perspective, at the time that the United States was created and formed, I don't see any reference that the federal government or a reasonable person believe that tribes have been divested of their ability to exercise jurisdiction over crimes or civil matters happening within a tribe's territory. So that would call into question implicit divestiture. Also, again, this idea that Scalia really expounds upon in his book, that courts state the law. Courts do not articulate what the law is or is not vis-a-vis the political branches. It's on the political branches to explicitly say, and here, when we're talking about Indian law, it's Congress to explicitly say, what they want the law to be. It's not for courts to opine what they think it would be. And we can look to Robert Rantoul, who was part of the law codification movement of the 19th century, where he says that the common law is the perfection of human reason, just as alcohol is the perfection of sugar. The judge makes law by extorting from precedents, which were themselves the extension of others, till, by this accommodating principle, a whole system of law is built out without the authority of or interference of legislators. And I think that's what we're seeing. I would argue that that's what we're seeing in the development of the common law as to implicit divestiture, that there's a lot of, well, it looks like maybe this is what legislators were seeing, or legislators were thinking about this in the 19th century, or were thinking about this in the 20th century, rather than looking at what the law actually was. And so for me, the conclusion is that we would eliminate implicit divestiture as a method through which tribal sovereignty can be abrogated, because it is inconsistent with an originalist understanding of the U.S. Constitution. And so that's where the article, when it is actually written, will eventually conclude. And with that, Spencer, can you go to the final slide, please? So Chepagwitch, so in my tribe in Ojibwa, that's how we say many thanks. And I believe we have 7 minutes, and so I'm happy to answer questions. And so I see that we have one question in. Please feel free to send if any additional questions that you might have. So the first question is, in which periodical do you plan to publish the series of articles you mentioned? And the answer is, I don't know. The way legal publication works is most journals will answer or will open up for publication in the spring. So we'll be submitting this article between January and March of 2026. And then hopefully one journal will agree to publish it, and we'll be able to get this out there. And we'll be happy to announce that via our normal, just how we announce publications through updates to you. And so hopefully we can make that available to you once it's published. I see that David also has a question, and he asks, can treaty making be resumed again, and what would that process look like? The answer is absolutely. It's Congress that ended treaty making in 1871. And so Congress, and that's under Congress's umbrella through the plenary power, which I mentioned briefly. And also, just as an FYI, I think the plenary power is going to be the next article or the next theory that we kind of tackle from this originalist framework. And so Congress could explicitly say that it wishes to renew treaty negotiations, and so essentially could undo that 1871 law that it passed. Also, interestingly, the president, even after treaty making was ended in 1871, the presidents continued to recognize different territories through executive orders. So there's also been presidential recognition of tribal sovereignty since that time period as well. And then Cody, I see that you have a question. So do other originalist members of the court follow the Scalia-Gorsuch position? So, that remains to be seen. We're kind of, it's interesting. Justice Thomas has expressed in several concurrences over the years in Indian law cases a deep frustration with Indian law. And he believes that many of the principles of Indian law seem inconsistent. And I don't disagree with him. I think he's absolutely right. He has said, so for example, in his concurrence in the Laura decision, that how can we have both tribal sovereignty and congressional plenary power? Those two things seem inconsistent. If tribes are truly sovereign, then how is it that Congress would have any sort of authority over that? So definitely Thomas is on record for saying that, this is kind of inconsistent, and the federal common law here has developed in a way that really seems unmoored to basic principles. He hasn't, I think he probably would come out in a different way than I might on the founding fathers' viewpoint of originalism interpretation of tribal sovereignty. But I think that there's enough there in his concurrences to suggest that he would support taking a look at implicit divestiture again, because again, it's kind of unmoored from originalist perspectives. Kavanaugh and Coney Barrett are still a little bit of question marks, although Kavanaugh has certainly written quite a bit about this originalist idea that, again, that the job of judges is to say what the law is, not to extrapolate what they believe the political branches think it is or is not. So he would seem to be aligned with the Scalia vision of originalism that we talked about. Interestingly, Justice Amy Coney Barrett was also at that 10th Circuit Bench and Bar conference. She was very generous in talking to us, as was Justice Gorsuch. Justice Gorsuch regularly attends as the 10th Circuit's quote-unquote justice. But it was nice to have Amy Coney Barrett there as well, and to really hear from her. She gave a wonderful presentation. So we're not quite sure yet where she necessarily stands on these issues, but it is possible that she would be open to investigating. And then we do know, actually, the other justice, in addition to Gorsuch, who has really been questioning whether we should continue to have these principles, is Justice Sotomayor. Has also been somebody who has been consistently going back to what was this original understanding of tribal sovereignty. I think she would come to probably the same result as Justice Gorsuch would, but I think she would come at it from an Indian canons of construction perspective rather than necessarily an originalism understanding. And both in terms of when we're talking about implicit divestiture, I think both would get you to the same results, regardless of which one you use. So they definitely, certainly support that. So thank you so much for spending an hour of your day with me today. It's really been such a privilege to chat with you about, as I mentioned, this kind of thought experiment and this path of exploration and scholarship that I am endeavoring to explore. And again, I hope you all enjoy Indigenous Peoples Day. I certainly take it as a time to think about everything that Indigenous peoples have brought to the United States to make our country even better, and the many contributions of Indigenous peoples that continue today. So I hope you have a wonderful day, a great week, and Che Miigwech, thank you very much for your time.